If a will is a document that says who gets your stuff after you pass, how does it do it? What it goes into the will to make sure that happens? My name is Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. In today's video, we're looking at part 2 of the content of a will. In part 1, we essentially looked at the 4 things that go into a will that make the probate process happen. In part 2 today, we're going to look at what we're trying to do, giving away our stuff. I hope you like today's video. Let's hop right into it with number 5. In a will, the 5th thing that we're going to do is define gifts. Now, that's the whole point of what we're doing, is we're identifying stuff and our money and assets and where it goes. But there are 3 different types of gifts in Minnesota. You'll know this if you've watched my other videos. Actually, there are 4 types of gifts, but in Minnesota, we only recognize 3. The first type of gift is a specific gift. That's where I give a specific item to a person. That's it, a specific item to a person. The second type of gift is the general gift. This is going to be one of 2 things. This is going to be a specific dollar amount given to a person, or it is an item that is a group of many that we're giving to a person. So if I've got 5 pens and I say Bill gets one of them as chosen by him or chosen by the personal representative or as chosen by a drawing, that's a general gift. And if I also give Bill $5,000, that's a general gift as well. The final type of gift is going to be the residue or residual gift. This is just a percentage of everything you got left after you've given out your specific gifts and your general gifts. I've given out my pens, I've given out my $5,000, I've got, say, another $20,000 left in my estate. 50% is going to go to Joe, 50% is going to go to Rachel. That's just a residual gift. Now, it is important to note that in Minnesota, it's customary to often lump your specific gifts and your general gifts and consider them the same thing. Or just give away specific gifts and don't give away general gifts. But if it's a general gift of a specific dollar amount, you call it a specific gift. That's okay. Just remember that if push comes to shove and for some reason of lapsing or redemption or other reason, there needs to be a priority of gifts. Specific gifts go first. General gifts, no matter what you call them, go second. Then goes the residue. The 6th thing that is going to go into a will is a definition of who the devisees are. Now remember, a devisee is someone who receives something as a matter or because of your will. Now, if in your will you say, I give this pen to Bill, Bill is a devisee. If Bill were to only receive something as a matter of law, which we'll talk about in just a moment, he'd be an heir. But right now, and he can be both at the same time, by the way. But let's talk about devisees. They're receiving something because of a will. Now, first thing we're going to do is when we're identifying gifts, we're going to identify who gets those gifts. Therefore, we've identified the devisees. A couple things to note. Make sure you have successor devisees. So not just the first person, Bill's getting the pen, but if Bill predeceases you, Susan's getting the pen. And if Susan predeceases you, it's going to be distributed per stirpes. Another thing to note is you can, of course, define your devisees as specific individuals. You can also redefine things like per stirpes. Per stirpes, of course, if you watch my other videos, you'll recognize that it means that if I give a gift to Bill and Bill predeceases me, his share is going to go to his kids in equal shares. But what if Bill and his children predecease me? But there's also his children have children of their own. So they'd be, if Bill was related to me, they'd be the great-grandchildren. I can redefine per stirpes or per capita or whatever you want to not be what the statutory definition is. And I can give it another definition that says per stirpes includes my great-grandchildren or grandchildren or whatever it may be. The 7th thing we're going to include in the will is the definition of our heirs. Now, as you recall, heirs receive something as a matter of law. For instance, if you don't do any planning under Minnesota statutes 524.2 2-102 and 103, I think. If you don't do any planning, those two statutes will determine who gets what of your estate. First goes to your spouse, but possibly your kids. If you don't have a spouse, but you have kids, it goes to the kids, etc., 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 down to next of kins and the laughing heirs way at the end. Another way that you can have an heir is if you have, for example, a spouse. Now, they're going to get something as an heir just for being your spouse, but they're also going to get an elective share. Or if there's a dependent that you're raising, they can get an allowance. This all makes them into an heir. A couple things to note. When identifying heirs, or essentially identifying our family, you should somewhere in your will say, this is who my spouse is, and these are my kids, even if one is predeceased you. When you're identifying your spouse, it's not a bad idea to identify your former marriages, if you had any, and identify how they ended. Did they end in divorce? Did they end in death? Because that helps during the probate process, gives a little bit more information that's sometimes hard to track down. Another thing you can do with heirs is you can disinherit people. You can say, my son Bob, he became a mime, and he's obviously going to make so much money as a mime, he is not going to need anything from me. So I'm going to flat out disinherit him and says he gets nothing. And that's okay to do. No offense to the mimes out there. Another thing, conversely, you can include other people, such as you can say, I'm married to my wife. My wife has children from a previous life or previous marriage. They're not my kids, but I help raising them from ages 2 and 3 up to being adults. I want them to be considered my children, and their lineage to be considered my children as well. The final 8th thing that we're going to find in a will is going to be a testamentary trust. Now, we've already alluded to these earlier when we talked about trustees in part 1, but it's, of course, it would be remiss if we didn't actually mention them as their own separate category. In my opinion, they're one of the most powerful tools we have in estate planning, and they're underutilized sometimes usually by attorneys that don't know what they're doing or what they can do. A testamentary trust is a trust built into a will. Because it's built into a will, and remember, wills have no legal effect and authority until you die, the testamentary trust doesn't exist until you die. And at that point, it springs into existence, it's managed by the trustee, and it will control assets after your death over time. We can do a lot of powerful things with this. We can do medical assistance, asset protection, as in supplemental needs trust, and we can do compulsive behavior trust. If someone's got a gambling or addiction problem, we can just make a trust for an individual and say your assets are protected from bankruptcy and creditors and everything else while the money's in the trust. It's fantastic for protecting assets from outside third parties, as well as protecting assets from the beneficiaries themselves. Now, there's a third term. Earlier we said devisee is someone who receives something in a will. An heir is someone who receives something as a matter of law. A beneficiary is someone who receives something from a trust. Note that if you have a revocable living trust, they're technically not called testamentary trusts. They're called subtrusts. I like calling them nested trusts. Either way, they're essentially the same things. The nice thing about testamentary trusts is we can just control that gift. It goes for education. It creates an allowance for as long as the kid doesn't fall off the wagon and start drinking again, etc., etc., etc. A lot of powerful things we can do. But that is number 8, and that brings us to the end of the video. Those are if you put 1 and 2 together, that gives us 1 + 2 = 8 categories of things that belong in a will. I hope you liked today's video. If you did like today's video, please feel free to like and subscribe. It really does help support the channel. We do a new video every other Wednesday. We've got some videos coming up on Jimi Hendrix and some interesting cases that I want to walk through. One that's coming up on guardianship. If you have any questions, leave them in the comments, or better yet, send me an email. I apparently get back to my emails a lot faster than I do for the comments. Otherwise, until next time, this is Gregory Singleton with Signature Law.